Good afternoon, friends. In today's video, I will be discussing evidence or proof in your immigration case. Most commonly, a person who is in immigration proceedings is going to be filing for asylum. So for our purposes, we're going to use evidence most commonly used in any asylum case. Thank you very much for watching. My name is Alina Shaltsova. I'm an immigration attorney from New York. I've been practicing immigration law in the United States for more than 15 years at this point, and I do handle a lot of cases in court. And this video is designed to help you to understand what is it that is required from you when you are going to immigration court. So thank you very much for joining me, and let's start. If you find yourself in immigration court, it means that the government is trying to deport you or send you back to your home country, and you would like to defend yourself if you have grounds for such defense. Again, most commonly, a person is going to be filing for asylum. Not necessarily. There are other reliefs from removal that one may qualify for, such as cancellation of removal, perhaps some waiver, even adjustment of status, and so on and so forth. But usually you will be filing for asylum. I would say that asylum filings, defensive asylum filings, constitute the most cases in immigration courts. So how are you going to do it? Well, of course, the burden is on you to prove that you qualify for asylum, just like for any other case. For any immigration benefit that you are seeking from the US government, the burden is always on you. It means it is your obligation to present sufficient evidence showing that you are entitled to relief you're declaring you are filing for. So let's talk about technicalities, how you can prove that you are entitled for such a relief. Well, you're going to be using evidence. And here I'm going to talk about two types of evidence that we as lawyers use in court most commonly to prove one's asylum case. First of all, we're going to be using witnesses. Witnesses are very important, and guess who is the main witness? It's you. You are the main witness for any of your cases in court. You are going to, first of all, fill out Form I-589 and then the penalties for perjury and other penalties. There are very severe penalties for signing Form I-589 and submitting false information. So never ever do it. Make sure that the information that you leave in the form is absolutely accurate. So your first testimony as a witness is going to be laid out in that I-589 form. And then you're also going to submit statement in support of your case. And then you're also going to testify in court, talk about your story, and the prosecutor and the judge are going to cross-examine you. So you are a very important witness for your case. And guess what's going to happen? The court is going to compare your testimony as you put it in your I-589 form and in your statement with your oral testimony during the individual hearing. And if there are any discrepancies, you will have to explain why there are any. And if you cannot, there will be raised serious questions about your credibility. It means that the court is going to doubt if you are telling the truth. So make sure you're preparing for your case very, very well. But how are you going to provide this evidence? Well, in written format. The main thing to remember is that when you are working on your statement, I always advise my clients to make the statement in a language most comfortable for them. Usually it will be their native language. And then they have to sign the statement in their native language, put a date when they signed it, and submit it for translation. I know there is an extra expense involved with regard to the certified professional translation, but it's best to handle the issue this way. Why? Because if there are any discrepancies between the original in your native language and let's say your testimony is the way translated during the court proceedings by the interpreter, you will always be able to refer to the original text, original statement that you provided in your own language. So this is how you submit your statement. Okay, very important. Then what other witnesses you're going to be using? Everybody else. This can be people who saw something, who heard something, or had similar experience. These people can be coming to court with you if they are available, but it's very rare. Usually they will be submitting also their written statements in their language with translation. Sometimes they can appear by video or even a phone call if it's possible. They do not have to be in the United States. They can be in any place of this world, but the testimony should be relevant to your case and helpful. And if the testimony is relevant and helpful, for immigration purposes, such testimony should be admitted as evidence by the judge for your case. Now, remember also one important thing. Witnesses, when they provide their written testimony, should again do it under the penalties for perjury. I find it that many people still do not know that in the United States, in immigration court system, it is allowed to present letters that are not notarized, as long as they are done in the form of declarations. What makes a letter a declaration? Just one sentence. I declare that the following. I declare under the penalties for perjury, under the laws of the United States, that the following is true and correct. And then the person signs the letter in the end, puts a date of their signature, and this letter became a declaration admissible for federal purposes in the United States. Very easy. And there is one more witness that you may be able to use. It's an expert witness. Expert witness is a separate witness. Why? Because his testimony or her testimony can be very helpful to prove future harm if we talk about asylum cases, or to prove, for example, that no similar medical care is available for you for cancellation of removal cases. Sometimes we have to make such a point. An expert usually is the person who has a large experience dealing with the country conditions of particular country, and also they should have a very strong CV or resume. And I've never had it in my practice, but it's possible that it can be a challenge to admit somebody as an expert witness. Sometimes a court or a prosecutor may doubt that the person qualifies as an expert. But if you are successful in convincing the court that this person is an expert in his or her area of expertise, their testimony and their reports are extremely helpful to win one's case, because the judge will not be able just to ignore their testimony. So as you see, it's easy to deal with witnesses, right? However, remember, every witness, even expert witness, should be prepared for your trial. But then there is another type of evidence that we use in court: documents. Documents are very important for every case. Immigration court system in the United States is not designed to accept anything else but testimony or documents. It means that you cannot submit a video file, something on a flash drive, or you cannot submit something with a hyperlink. Or judge, just click on that link and it's going to take you to a relevant document. It doesn't work like that. You have to translate, convert all these types of proof that you may have into paper format. Take screenshots, take transcripts, but it has to be paper format. The United States immigration courts do not insist that you provide notarized copies or apostilles. You don't. It's easy, basically, to copy a document or to convert it and provide it to court. Again, the same rule applies. Any relevant, helpful evidence is going to be admitted, or should be admitted, rather, because it's decided by the judge, into your case as proof. When we talk about the documents in the case, don't forget that we also, in the context of asylum cases, often use something called country conditions. This is a separate type of evidence, separate from expert report. Country conditions evidence can be anything from reports by the international organizations or Department of State or news articles regarding the situation in your home country. It helps you usually to prove certain point, certain treatment that you may be expected, or certain things in the past. So now you see that it's not that difficult to deal with proof or evidence in immigration court. I hope you find this video helpful. If so, please like and share it, and I hope to see you soon.